Okay, good evening, everyone. Okay, that's where you say good evening back. Thank you. My name is Marcelyn Burke, and I'm the Dean of Tulane Law School and the Mitchell Franklin Professor of Law. And it is indeed my great privilege to welcome you to the Eason Weinmann Lecture on International and Comparative Law. As far back as the 19th century, Tulane's first president, William Preston Johnston, hailed the science of comparative jurisprudence as the defining strength that made Tulane Law School unique among American law schools and one of the nation's finest. Today, in the age of globalization, law schools everywhere are scrambling to claim a global reach. Yet Tulane staked its leadership on this ground more than a century ago, at a time when most of today's law schools didn't even exist. Indeed, the first two lectures delivered at Tulane Law School's founding in 1847 were on comparative law and admiralty, two of our historic strengths. Louisiana, with its distinctive civil code surrounded by common law neighbors, provided a natural laboratory for Tulane's early strength in comparative law. But it required shrewd leadership and vision to capitalize upon that advantage and develop Tulane's preeminence in a field of growing academic and practical importance. Since 1981, Tulane's leadership in comparative and international law has been sustained through the Eason Weinmann Center for International and Comparative Law, established through the generosity of Ambassador John Giffen Weinmann, class of 1952, and his wife, Virginia Eason Weinmann. Ambassador Weinmann built an extraordinarily distinguished career on the international stage. First as a partner for nearly 30 years at New Orleans Phelps Dunbar firm, then as president of the Waverly Oil Corporation, and finally as U.S. Ambassador to Finland and Chief of Protocol in the White House, seeking to advance the foreign policy goals of the United States by creating an environment for successful diplomacy. Ambassador and Mrs. Weinmann have each served in important leadership positions in higher education. Ambassador Weinmann as the chair of the Tulane University Board of Administrators, and Mrs. Weinmann as a trustee at her alma mater, Connecticut College. The Eason Weinmann Center is now recognized internationally for its ambitious research initiatives as a magnet for leading scholars from around the world, and of course, for the Eason Weinmann Lecture that we're here for today. The impact of Ambassador and Mrs. Weinmann's loyalty to Tulane and their vision for excellence can be seen everywhere in the halls around us. Of course, in the Eason Weinmann Center, co-directed by Professors Vernon Palmer and Jorg Fecke, in the Eason Weinmann Chair, and then in the actual walls around us as we gather here in the magnificent Weinmann Hall. Although Ambassador Weinmann passed away in 2016, we continue to feel his presence very much so at this lecture and in so many other aspects of the law school. And we are honored to be joined by Mrs. Weinmann this evening, who has continued to be a stalwart supporter of this lecture, the center, and the law school. So I invite you to join me in acknowledging and thanking Mrs. Weinmann and Ambassador Weinmann for their generous leadership. And with that, I will now turn the podium over to Professor Fecke to introduce tonight's speaker. Thank you.
I think I can do this without the microphone. Can everyone hear me?
Yes.
Yes.
Excellent, excellent. There are advantages to small audiences. Dear Mrs. Eason Weinmann, dear Dean Burke, students, Students, hands up. I'm kidding.
There he is.
Students and colleagues, there we go. There are more. There are more. Ladies and gentlemen, dear Professor Tridimas, dear Takis. Many thanks, dear Dean Burke, for this wonderful introduction. We are grateful for your encouragement and look forward individually and as a center to work with you on all matters foreign, comparative, and international in the years to come. Many, many thanks also to Virginia Eason Weinmann for attending the event tonight. The Dean has already told us much about the incredibly generous and sustained support that you and your husband, Jack, have provided to the university, the school, and the Eason Weinmann Center over such a long period of time. I add the thanks of the center, my co-director, Professor Vernon Palmer, and the many students and colleagues that have benefited from this generosity in so many different ways. Just this past month, we hosted a colleague from Austria, Professor Christoph Betzemek, who taught a popular and incredibly topical course on comparative free speech and interacted with many faculty members during his stay here in Weinmann Hall. He could not have come, he could not have taught, and he could not have participated in the intellectual life of the school without the creation of the center and the funding of its various activities. Before I introduce you to tonight's speaker and his topic, I want to use the opportunity to reflect very briefly on this endowed lecture series, for without your support, it too would not have come to life and developed into what I, in all modesty, regard as a unique success story. Karl Baudenbacher, Xavier Blanc-Jouvin, Ole Lando, Patrick Glenn, Basil Marquesinas, Günther Frankenbach, Antonio Gambaro, Jeffrey Jowell, Hein Kurtz, Bernhard Schlink, and, wait a minute, Vernon Palmer are only a few of the 24 stars from the world of foreign comparative and international law that have made their way to New Orleans and offered their ideas and perspectives to this audience. They have brought to the school the experience and knowledge of legal practitioners, judges, and academics, and enhanced our intellectual environment with stimulating, entertaining, and sometimes controversial, but always cutting-edge insight to issues that affect the legal world, both within and outside our national borders. I regard this as an invaluable contribution to the mission of this law school. We compete, as many others, for the best young minds in America, and must provide an excellent American legal education for them. This was critical for Ambassador Weinmann, an alumnus from the school and a practicing lawyer with Phelps Dunbar for 28 years. But the ambassador also understood and supported a legal education that reaches beyond our borders and seeks to engage with the world outside, be it foreign or international. And it is in this mindset and legacy that both the center and this lecture series seek to carry forward. Professor Tridimas, founding director of the Luxembourg Center for European Law at the University of Luxembourg, is the perfect candidate to take over the baton tonight. He is a leading scholar in the field of European Union law and one of the most frequently cited authors by the Advocates General of the European Court of Justice and on matters of EU law by English courts. Previous positions in his academic life include King's College London and Queen Mary in London also, and as law clerk to Advocate General Sir Francis Jacobs, the European Court of Justice. He has advised European institutions and national governments on a wide array of legal issues, and recently headed an international group of scholars in pursuit of what are the key characteristics of a European liberal democracy. He has also taught and researched for many years on this side of the Atlantic at Pennsylvania State University and now at Florida State, and has taught in a visiting capacity at many other institutions, both in Europe and the United States. He is a barrister at Matrix Chambers, again in London. It is this experience with so many legal systems and personal involvement, both on the academic side and legal practice, that make him the ideal person to explore in a comparative perspective constitutional rights and democracy. We live in truly extraordinary times. Overlapping legal spaces like tectonic plates are again shifting, be it in the guise of speeches in Munich, threats of tariffs in Washington, or fundamental questions and doubts with respect to international organizations that have shaped our post-World War II global order for decades. Tonight, we warmly welcome Professor Tridimas as our guide through a part of this rapidly changing reality. I much appreciate the effort you have made, Takis. It wasn't easy. He was stuck at the airport, Louis Armstrong International, until 5 a.m. in the morning when he arrived. So he really made an effort. I really appreciate this, Takis, as I know Ambassador Weinmann, himself a diplomat, and so interested in the world outside, would have. Many, many thanks for coming. The floor is yours. The keyboard, then you have more space. Click on it, see what happens. Oh, there you go. It's there. That's what I do. I just keep on clicking. Just click, 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 whatever. Eventually it's there and all is well. All is well. You're doing just the right thing.
Good. Thank you very much, distinguished colleagues and guests, ladies and gentlemen. Thank you. Thank you for this introduction. It is a great privilege to be invited to give the 2025 Eason Weinmann lecture. I feel very honored, and I am very grateful for the invitation, very grateful indeed. I deliver the lecture with great pleasure, but also in view of the tradition of this law school and the names of the caliber of the past speakers with some trepidation. The theme of my lecture is constitutional rights and democracy, and my focus is on the role of the Court of Justice of the European Union, which engages in constitutional adjudication and performs a role in many respects similar to that of the United States Supreme Court. Constitutional courts, or in any event, courts which stand at the apex of the legal order, are called upon to resolve conflicts among juxtaposing rights, principles, and interests. Conflict resolution entails prioritization, ranking, and sometimes balancing of countervailing interests. And this in turn raises profound questions about the separation of powers and the proper limits of the judicial province. A distinct feature of post-war European constitutionalism is that constitutional adjudication is not the exclusive province of national courts, but it is also performed by the European Court of Justice, the highest court of the European Union, and also the European Court of Human Rights, who is tasked with applying and interpreting the European Convention of Human Rights. And when balancing takes place at supranational level, the judicial exercise acquires added dimensions of complexity. When the Court of Justice is faced with a conflict, say, between the right to free speech and the right to privacy, essentially it has to decide two issues. First, it must decide how the conflict should be resolved, but it must also decide whether the conflict should be resolved at EU level, or how much of it should be resolved at EU level, and how much of it should be resolved at state level. and the Court of Justice has this delicate task of overseeing the political bargain established by the EU treaties, which is incomplete, it is vigorously dynamic and unstable. My talk this evening attempts to explore selected issues concerning this balancing exercise carried out by the Court of Justice. I will first provide a brief introduction outlining what I see as the shifting constitutional paradigm of the European Union. I will then try to present the universe of conflicts that arise in EU law and seek to provide a typology of such conflicts. And finally, I will attempt to identify some of the factors that the Court of Justice takes, or it should take into account, in resolving them, and selectively discuss some of them. First introduction, just going back to basics. The European Union is a supranational organization that was born from the ashes of the Second World War. The journey started in 1952 when 6 European states, including France, Germany, and Italy, established the European Coal and Steel Community Treaty. The idea was that if decisions regarding the production of coal and steel, the basic materials for the war industry, were entrusted to a supranational organization, the possibility of another European war would become more remote. The European Coal and Steel Community Treaty was followed by the European Atomic Energy Treaty and the European Economic Community, a more general treaty which provided for economic integration. The objective was to achieve peace and prosperity through economic interpenetration. The idea essentially was to make up for the inability of the nation state to ensure peace and prosperity for its citizens. I can put it to you more poetically. There is a school in Scotland which was built at the end of the 19th century, and it was built in neoclassical style. It has 3 grand pillars in the front which support a pediment, and in 1920, in the first pillar, the names of the pupils of the school who lost their lives in the First World War were inscribed, and there were many of them. In 1946, the names of the pupils who fell in the Second World War were carved in the second pillar. So when students sometimes ask me, what is the European Union all about? I say it is to make sure that the third pillar remains empty. Since the early 1950s, the journey of European integration has gone a long way. The European Union now has 27 member states, an advanced institutional structure, and power to legislate in virtually all areas of economic and social life. European Union law, just as federal law, here takes precedence over the law of the member states. And in essence, the European Union has both an economic and a substantive constitution. The economic constitution is based on the 4 fundamental freedoms: the free movement of products, of persons, of services, and of capital. There is also a set of common policies that range from a common antitrust policy to a common policy on agriculture and the environment. And there is also an economic and monetary union. A subset of member states share a common currency, the euro. The substantive constitution of the EU is based on the EU values, the general principles of law as they are extrapolated by the Court of Justice from the laws of the member states, and the Charter of Fundamental Rights, which enshrines civil liberties and social rights and became binding when the Treaty of Lisbon came into force in December 2009. And the 2 treaties which found the European Union as it is currently in force is the Treaty on European Union and the Treaty on Functioning of the European Union. Let me say one word about Article 2 of the Treaty on European Union. This is an ambitious provision, in some respects overwhelming in its generality and abstraction. The Union is founded on the values of respect for human dignity, freedom, democracy, equality, the rule of law, and respect for human rights, including the rights of persons belonging to minorities. These values are common to the member states in a society in which pluralism, non-discrimination, tolerance, justice, solidarity, and equality between women and men prevail. Very ambitious indeed. The trouble with these principles, the beauty of them is that they're so general that they facilitate political consensus. Who would disagree that gender equality is a great idea? Freedom of speech, very good news. Non-discrimination, solidarity. But not all of us come to the same outcomes from these principles, especially because in most cases they would be in a trajectory of conflict. So we need intermediaries to make the transition from principles to outcomes, and it is essentially the courts in a democratic society that ultimately are entrusted with reaching outcomes. Let me just say one word about Article 2. It operates at different levels. It operates at a moral level, if you wish. It operates at a political level, but it also operates at a legal level. It has, it is not devoid of legal content. So what are its normative illustrations? Well, here they are, as I understand them. First, respect for these values is a condition for admitting a new country to the European Union. And in these turbulent times, there is a long list of candidates, a long line of candidate countries, including now Ukraine. Secondly, a serious and persistent breach of those values, or a clear risk of them being breached in a serious way, may trigger a particular enforcement procedure, which is political in nature rather than legal, and which may result in the other member states ultimately removing the voting rights of the member state which is found to have committed or be in risk of committing such a serious and persistent breach. Thirdly, Article 2 has interpretational force. It guides the interpretation of other provisions of the treaty. And indeed, the Court of Justice, in a recent case arising from the rule of law crisis in Poland and Hungary, referred to the values of Article 2 as the constitutional identity of the Union, as having normative force in a juxtaposition of the arguments that those governments put forward. And finally, it has also been used by the court together with Article 19, paragraph 1 of the Treaty on European Union, which provides that member states must provide effective remedies for the protection of EU rights, to impose systemic obligations on the member states. In particular, it requires, the court says, Article 2 together with Article 19, it requires member states to comply with certain minimum requirements in relation to the administration of justice. They must guarantee judicial independence. They must guarantee access to justice because, in the view of the court, the judiciary is not only a national judiciary, but also responsible for applying EU law. Every national court is potentially a European Union court, and therefore it cannot perform that task unless it fulfills a minimum systemic requirements. So Article 2 has facilitated, if you wish, the transition from individual rights, which are for the Charter of the European Union to grant, to certain governance principles. In a more recent case, the Court of Justice appears to suggest that because of Article 2 and Article 19 on the obligation to provide remedies, member states must guarantee certain democratic principles, like the right to vote, and extend that right to vote when it comes to European elections also to citizens of other member states. So I think Article 2 colors the way the European Court of Justice performs this function. It has increasingly acquired the function and the characteristics of a constitutional court. And if you look at the most important cases decided by the Court of Justice over the last 20 years, they are constitutional law cases rather than commercial law cases. They are no longer about free movement of services or products. They are about civil liberties. How do I define the most important cases? Well, I use two criteria. First of all, I look at the cases that have been referred to the Grand Chamber, to the highest court formation, and I think the majority of them raise issues of fundamental rights. And I also look at the court's annual report, so that the court itself makes a selection in its annual report, what it considers to be the most important cases, and using that criterion, again, we find that the majority of those decided are not the kind of cases that an international tribunal would decide, but rather the kind of cases that a court would decide, a constitutional court would decide. So allow me to illustrate the constitutional adjudication that reaches the Court of Justice by reference to four cases. The first example is the Common case, one of the most cherished principles of European Union law is the free movement of persons. Article 45 of the Treaty on the Functioning of the European Union provides for the free movement of workers in the EU, and this is supplemented by other provisions which facilitate free movement of self-employed persons and corporations. And EU legislation that concretizes this free movement right provides that a citizen of an EU member state who moves to another EU state to take up employment or who otherwise is entitled to move can bring with him or her their family members. And that makes perfect sense. Otherwise, free movement would be illusory. So Mr. Common was a Romanian citizen who, while working in Belgium, got married to Mr. Hamilton, an American citizen, under Belgian law, which allowed same-sex marriage. Mr. Common then returned to his native Romania, but the Romanian authorities refused to recognize Mr. Hamilton as Mr. Common's spouse, and therefore refused to grant him a right of residence on the ground that under the Romanian Civil Code, marriage between people of the same sex is not recognized. Should the Romanian rules on marriage give way to the right to free movement? The second example, you will forgive me if I keep you in suspense as to the result of these cases. Second example comes from the Omega Spielhallen case. The regional authorities of Bonn in Germany refused to license a laserdrome on grounds of public policy. Laserdromes, I understand from my children, provide a venue for entertainment where players wear laser-tagged suits and engage in a laser battle, a game somewhat similar to paintballing. But the German authorities considered that a laser battle simulates homicide, and thus runs counter to the principle of the right to human dignity, the most revered right in the German constitutional order, which features in Article 1 of the German Basic Law. The argument in American ears may sound very far-fetched. The Laserdrome was serviced by a British company. Britain at that time was a member state of the European Union, who in turn complained that German law interfered unlawfully with the cross-border provision of commercial services. Should the commercial freedom of the Laserdrome trump the German constitutional principle? The case, I think, provides a point of sharp contrast with the judgment of the Supreme Court in Brown versus Entertainment Merchants Association, and I hope to have time later on to come back. Third example, Google Spain. This concerns the interpretation of an EU measure on the protection of individuals with regard to their personal data and their processing. The origins of the case lie in a complaint lodged by Mr. Gonzalez with the Spanish Data Protection Agency against Google. He complained that when his name was entered into the Google search engine, the results showed links to archived pages of a regional newspaper, which were some 30 years old, and which contained information regarding the sequestration of his property because he had failed to pay social security debts. The Spanish authority actually upheld the complaint, whereby Google objected that it was not responsible for the publication of the data. All it was doing was collating data that already existed. Why should it be responsible for what is published in Spanish newspapers? And the final example is RT France versus Council. The European Union imposed a broadcasting ban on the French subsidiary of a non-profit entity based in Russia, which was funded by the Russian state. The ban was imposed as part of the sanctions against Russia following the invasion of Ukraine in February 2022, whereby the French company complains that its freedom of expression, its right to free speech has been violated. So all the above cases entail conflicts among competing interests, and most of them involve what I call multi-dimensional balancing. This means what I said earlier, that there are in fact two issues that need to be decided. First, they raise the issue whether these conflicts should be decided by the Court of Justice, whether they should be subject to European Union law, or whether they should be left to national law to decide. And secondly, they raise the issue of how the conflict is to be resolved. Let me just delve on this for a minute by reference to what I think is one of the most important cases decided recently by the European Court of Justice, the animal slaughter case. It is part of a series of cases on religious freedom and religious equality, which in recent years have somewhat perhaps surprising occupied the Court of Justice. So here it is, just to make the context is a bit complicated. It's complicated in all these cases. So just to make it a bit easier, the transparencies provide the background. So what we have is an EU regulation, essentially EU legislation, which requires the stunning of animals before killing on animal welfare grounds. But there is equivocation, because Article 4, Paragraph 4 of the regulation provides an exception in relation to slaughter prescribed by religious rights. In relation to such slaughter, there is some requirements need to be fulfilled, but there is no requirement of stunning. Nonetheless, another provision of the regulation, Article 26, allows member states to provide more extensive protection of animals in relation to slaughtering in accordance with Article 4.4. So the two exceptions appear to point to different directions. And what we have in this case is a Belgian decree, a Belgian measure. It comes not from the federal government, but from Flanders, the regional government of Flanders, which prohibits essentially animal killing without stunning, and therefore outlaws religious practices. And the action here comes from groups of Jewish and Muslim organizations who consider that the Belgian decree violates their rights. So there are two issues really in this case. The first issue, the case goes before the Court of Justice because it pertains to the interpretation of EU law, and the issues are the following. First, does Article 21, which permits member states to provide for a higher level of animal protection, enable them to require the prior stunning of animals, even in the context of religious slaughter, and therefore undo the derogation introduced to give effect to religious freedom. And the second one was, if the regulation allowed that, does the Flemish decree in any way is compatible with freedom of religion as protected by Article 10 of the EU Charter? And the Court of Justice first came to the conclusion that the derogation in favor of religious freedom operates without prejudice to the power of member states to restrict it. In other words, the court says the regulation makes here an incomplete bargain. It provides for an exception in favor of religious freedom, but this exception only applies in the absence of a majoritarian choice at the level of the member states. Flanders could restrict religious freedom more. And then the court goes on to examine whether the restriction on religious freedom was proportionate. It comes to the compatible, and comes to the conclusion that it was. To me, it seems that it would be unthinkable for an American court to come to the same conclusion. The Church of the Lukumi Ubabulu I is a sharp contrast with the outcome in this case. And the case, I think, illustrates what I call multidimensional conflicts, tensions which exist at different levels. There is first a horizontal conflict between, on the one hand, religious freedom and animal welfare, and superimposed on that is vertical balancing between EU and state freedom, state autonomy. Interesting that the court doesn't refer to animal rights, because then you would have to get into a discussion as to who can assert the right. It talks about animal welfare as being a value of the European Union. And in the circumstances, gives it essentially preference over religious freedom. An interesting conflict between an old and a new right, if you wish. Secondly, the court really leaves the balancing to the member states. Essentially, it is a nation-state friendly judgment. The balancing need not be done at EU level. Member states can differ in this respect. That's a very different approach from the approach that the court takes when it comes to gender equality, for example, or where it comes to the right to judicial protection. Okay, so Allow me then to move to the next section, which is trying to map out the universe of conflicts, as I call it. What kinds of conflicts come before the Court of Justice, and many of them would be familiar to an American constitutional lawyer, indeed all of them. All of them mutatis mutandis. So first of all, we have a conflict between the EU public interest on the one hand and fundamental rights protected by EU law. So an EU measure would conflict with a charter right. The Arty France case is a good example. Yeah? European law prohibits broadcasting or by an organization controlled by Russia. So here the plane occurs really in the field of European Union law, and the Court of Justice has complete jurisdictional control. Annulments of EU measures, especially policy ones, or on the ground that they conflict with EU fundamental rights, are rare, but they do exist. They do happen. And I think looking at the case law, there are three rights to which the Court of Justice appears to pay particular attention and which have very powerful force. These are due process, the right to judicial protection. It is the right to non-discrimination, especially gender equality, and the right to data protection. These are the three rights which in quantitative terms have led to the annulment of EU measures. The Cadi case is the locus classicus for due process. Mr. Cadi's assets had been frozen following September 11. The economic sanction imposed on him was not the initiative of the European Union, but it was the initiative of the UN Security Council, which essentially operated after 9/11 as a generator of administrative law. Assets of individuals who were identified as a result of intelligence information as being associated with Osama bin Laden had their assets frozen. Now, this is not a criminal measure. It is a restrictive, it's an administrative measure, and the Court of Justice in Cadi decided that the freezing order was subject to judicial review, even though it emanated from the UN Security Council. The Court of Justice says essentially, it doesn't matter what is the ultimate source of the measure, the EU may not act with impunity, and because Mr. Cadi had not been given any reasons, the court annulled the freezing of assets, although it preserved it in effect, giving the opportunity to the European Union to come up with a meaningful statement of reasons. So Cadi suggests that there is, if you wish, an enclosed constitutional space in the EU. It cannot be penetrated by international law. Anything that the EU does has to comply with these fundamental rights. Second category of conflicts these are between a national interest and fundamental rights recognized by EU law. So here the conflict is different because the public interest which is being protected is not an EU public interest, but a national interest. And this is the locus classicus of constitutional adjudication, where the EU integration game plays out. Common belongs to this category. What we have is the juxtaposition here of the right to free movement with one's family members on the one hand, and the national interest to preserve marriage as a heterosexual legal relationship, on the other hand, according to Romanian law. So this category is in many ways the most sensitive one because it juxtaposes supranational rights with domestic democratic choices. And the more the competence of the EU expands, the more it covers contestations that do not involve issues of free movement. Third area, or third kind of conflict, those arising between objectives of EU, the public interest of the European Union this time, and fundamental rights recognized by national. So this is the opposite. Here, the fundamental right is used as a trump card against integration, and it happens increasingly because the EU has in many ways assumed the character of a regulatory state. To give you an example, there is a European arrest warrant which essentially facilitates the surrender of someone who is being prosecuted by the authorities of one member state from the authorities of another member state. The European arrest warrant sometimes may come into conflict with national due process requirements. In Meloni, the court had to decide whether it is possible to issue an arrest, whether a country was required to surrender an individual that was in its territory, even though that individual's surrender would be against national constitutional standards. Spain, at that time, had a constitutional prohibition on convicting someone in absentia. If someone was convicted in absentia, even if it was his responsibility, even if he was fully informed and was able to appear and chose not to, that would require a retrial and could not give rise to a valid conviction. And the final category is conflicts of rights inter se. The Google Spain case is a good example of that, where we have the juxtaposition between the freedom of expression on the one hand, and, or indeed the freedom to conduct business, which is recognized as a fundamental right that Google was asserting, and the right to privacy, on the other hand, that the individual was asserting. Now, these categories, we must bear in mind that they are not totally independent. I think they are quite porous, and the conflict that belongs to one category may well raise issues pertaining to the other. Okay, so next point, what are the factors that a court takes into account or should take into account in deciding how to resolve these conflicts? So here is a selection of them. At the moment, my presentation is descriptive in the sense that, or analytical. In other words, these are the factors which appear to me that the court takes into account by looking at the case law. Whether it should take them or not, I'm happy to enter into an individual discussion on a case-by-case basis. So, first of all, the importance of the right at stake. Clearly, other things being equal, the level of constitutional tolerance is in inverse proportion to the ranking of the right in the normative hierarchy. The more important the right, the more difficult, one would have thought, is to justify a restriction on it. Now, in European Union law, there is no tiered scrutiny in the way we understand it in US constitutional law. The Court of Justice very rarely addresses the level of scrutiny that it applies, although in recent case law it has provided some hints. Nonetheless, it is, as I said, perfectly reasonable to expect that the importance of the right will have an influence on the level of scrutiny. And I would identify again the same rights which appear to me to be at the apex of the hierarchy: the right to due process, the right to non-discrimination, and the right to personal data. The most important right, the most precious right in EU law is the right to due process. I think there has been enormous activism on the part of the Court of Justice, but we must also bear in mind that it is colored by what the Court of Justice views as the imperatives of European integration. So yes, the rhetoric is very high, but the Court of Justice has held, for example, that the jurisdiction of investment arbitration tribunals is incompatible with the treaty insofar as they are called to resolve disputes between the member states of the European Union. So this is a restriction on the right to judicial protection. The court essentially is very eager to retain the monopoly of a jurisdiction where it comes to issues that pertain to the interpretation of EU law. So second factor, the extent to which the right has been the subject of legislative elaboration. In other words, whether someone is invoking a right that exists in the plane of constitutional law only, or whether someone is invoking a right that has been articulated in EU legislation, does make a difference. It is a relevant factor in many respects. The greater the degree of specificity of the right and the restrictions imposed on it, the less margin of discretion for the member states, primacy and preemption take over. There are many cases in this respect. All I would say, though, is this, that the fact that the right is elaborated in legislation does not necessarily mean that it will enjoy a higher level of protection. There have been occasions where the court has interpreted the right to free movement very broadly indeed. Then the EU legislator has come in to restrict the right to free movement, and the Court of Justice has found that these restrictions are perfectly compatible with the treaty provisions which it had previously interpreted rather broadly. So majoritarianism here, the fact that the EU legislature has spoken, plays an important role. The seriousness and extent of the restriction, clearly that is important, and I will delve on this in a minute. Let me go through the list because I don't have time to discuss all points, but I'll come to just one of them or two selectively. Of course, the importance of the countervailing public interest, if it is public policy, public security, anti-terrorism, is a relevant factor. Process considerations, what is the procedure that has been followed, clearly an important factor. And the perceived degree of consensus among the member states. The court refers to the common constitutional traditions of the member states and extrapolates principles, but the truth is that this is a really an alibi for the court to do whatever it likes. It never engages in a comparative analysis of national laws. In a famous case called Mango, the court said there is a general principle of non-discrimination on grounds of age, and at that time only 2 constitutions in the EU provided for that. And the court also went on to say that, in fact, the principle is horizontally applicable. It can be asserted by an employee against their employer. Let me just say one word, because I know time is getting on. One word about the seriousness and extent of the restriction. Here, methodology differs. That is, I think, the sharpest difference between American courts and the European Court of Justice. In EU law, essentially, a restriction is assessed by reference to 2 factors. They are provided in Article 52 of the Charter, which states that to be lawful, a restriction on a right must fulfill 3 conditions. First, it must be provided by law. That's a process requirement, and it makes perfect sense. And of course, it's not only an EU requirement. Second, the restriction must respect the essence of the right. And thirdly, it must be proportional. So allow me just one word about the concept of essence. It is a highly elusive concept. Essentially, I think what the court is saying is there is a core element of a right that cannot be interfered with. It is beyond bargaining. And that makes perfect sense. But how can a court determine the essence of a right? Whilst the distinction is logical, in practice, it is extremely difficult to draw the distinction between essence and periphery. It cannot be, the essence of a right cannot be defined subjectively from the point of view of the right holder, nor can it be defined a priori without reference to context. I mean, clearly, imprisonment is a restriction on one's right to free movement. That doesn't mean that an imprisonment can never be allowed. So if essence was understood so widely, then it would become overbearing and incapable of accommodating the values of the legal system. Essentially, I think the difficulty with essence is that to determine these core elements of the right, we need to look at its objectives, its context, and its position in the normative hierarchy. And we also need to look at the limitations imposed on the right. More importantly, a court does not approach essence as a philosophical point. It does it in the context of a contested specific restriction. So the definition of essence gets entangled with, among other things, the intensity and the extent of the violation. So the discovery of essence is a process which can only, or at least best, be undertaken inductively rather than deductively, reaching an abstract solution after observing restrictions on specific cases. In short, although essence as a legal threshold is to be understood as an autonomous limit, in effect, it is impossible to determine it without engaging in a balancing exercise. It is therefore conceptually very difficult to separate its application from the application of the principle of proportionality. I will not bore you with the principle of proportionality. I'll be very happy to defend it. However, proportionality essentially means 3 things: that a measure A restriction on a right must be suitable, it must be reasonably likely to achieve its objectives. It must be necessary. In other words, if there are alternative ways of pursuing the public interest in view, the government should choose the least restrictive. And thirdly, it also means what the courts refer to as stricto sensu proportionality. It must not interfere more than it is necessary with a right or the value of the legal system. Proportionality has proved a popular export, and I think there is no other principle that encapsulates better European constitutionalism than that principle. I think it can be said to form a global standard of justice, but it has also met very strong resistance on the ground that it gives too much power to the judiciary. It is not as such followed by American courts, although one can trace conceptual equivalence. And I can perhaps finish this with a reference to Chief Justice French of Australia, who in Murphy versus Electoral Commissioner referred to proportionality as an exotic jurisprudential pest destructive of the delicate ecology of the Australian public law. So I just to relativize my praise of it, it is by no means something that all constitutional lawyers would value. So where do we stand? I think it is important to emphasize the central role that the Court of Justice of the European Union plays in constitutional adjudication and in exporting standards of justice to the member states. I think overall my assessment of the case law would be positive. I would be happy to take issue with specific judgments and specific outcomes, but I would not question the legitimacy of the Court of Justice. Inevitably, as the case law progresses, it goes through corrective readjustments, a polite way of saying that the court does not always respect precedent as things change. And I think that the legislative activity of the European Union in recent years has led to a number of systemic principles of EU law which themselves come into conflict with fundamental rights. There has been a bit of a shift, whereas in previous eras, fundamental rights and European integration were convergent forces. Now, increasingly, they are in a trajectory of conflict. The more the EU behaves as an imperium, the more the chances of a conflict between them. Thank you very much for listening.
Thank you very much, Takis. Stay there, because we might have some questions. We have a little bit of time, and I think you are willing to take some questions.
Absolutely.
So thank you very much, first of all, for this lecture. I found a number of points intriguing, but I want to ask the audience first, are there questions from your side? There we go. David.
Thank you very much for coming to Tulane tonight. My name is David Katner and I'm on the faculty here. My question deals with the concept of the right of freedom of movement. Is the right restricted to the jurisdictional territory of the Court of Justice, or could it be expanded beyond territorial limitations? So for instance, if you have an EU citizen who has dual citizenship in different countries, and say he or she is involved in an altercation at a third location outside of the EU, and maybe a group of Americans intervening in the third location decide to remove that person from a place where perhaps a battle is going and transport them to yet another location. We'll call it Guantanamo Bay. In the event that something hypothetical like that happened, would the Court of Justice, under the principle of the right of freedom of movement, would they have jurisdiction to intervene if they even knew that an EU citizen had been transported against his will, which might constitute an act of kidnapping? And would they consider giving jurisdiction to a case such as that, do you think?
I mean, that's very interesting. The short answer is no, because there wouldn't be, the court would only have jurisdiction. Free movement imposes obligations on the member states, on the public authorities of the member states. The court has also said that it may apply horizontally. It may impose obligations on individuals. For example, a bank could not refuse a job to someone on the basis of their gender or their ethnic origin. But it would not be possible for the free movement of goods, of persons, or indeed any other freedom, to impose obligations on third countries. Now, so that is a starting point. Now, of course, to the extent that any EU public authority has facilitated or has allowed what you described to happen, one could say that it has breached its obligations. In other words, it is not unthinkable to consider that member states have a positive obligation to resist an EU national being surrendered to a third country or being maltreated by a third country, if that would violate certain charter rights. But that, it would only therefore be reflective. The issue of positive obligations, in other words, to what extent EU states must protect EU citizens vis-a-vis third states, has only marginally been touched by the court, but there are a couple of cases.
Adina?
Very interesting. Thank you for the lecture. A couple of questions. First, this seems to be a court that is accumulating a great deal of money. How has the response from the various member states been to this fairly extensive power? The second question is more complicated, and that is about Article 2, which seems to be kind of preamble, like a preamble to a constitution, was least of all. To what extent does Article 2 help the court to decide as to whether or not a right is important and or what the essence of that right is? And I thought the Flanders decision was counterintuitive, and I just wondered whether or not Article 2 played any role in that decision as well.
Okay. Yeah, thank you very much. First question, what has been the reaction to the Court of Justice? I would say the reaction at two levels. First of all, I think judging by how European integration has progressed, the court has been a winner. We have had successive changes to the EU treaties, and these generally have been pro-integrationist. In other words, they have transferred more power to the European Union. They have made the decision-making process more federal, in that most decisions are taken by the member states by majority rather than by unanimity. So the progress has been, the trajectory has been one of more integration. So I would say member states have essentially provided ex post endorsement of court developments. I wouldn't say they have followed it with enthusiasm. The word acquiescence comes to mind. It's on a cost effectiveness account. It's okay. They feel that they benefit more by having by continuing to be members of the European Union, despite what the court does. So I would say it's a matter of ex post legitimacy to what the court does. Now, the national courts have also gone along the same lines, but there have certainly been conflicts. Perhaps the sharpest conflict has been with the German constitution. Well, the sharpest one has been with the Polish a court, but that's almost, I would say, beyond the range, because the Polish court did not really intervene as a judicial actor. It simply said that we don't accept the primacy of EU law, and it was really a ruling which was highly political. The more interesting engagement has been with the German Constitutional Court, which has progressively become more assertive, and that reached its apex in a case called Weiss, where the federal court refused essentially to follow the interpretation given to acts of the European Central Bank by the Court of Justice. What is interesting is that the conflict has occurred not on an issue of protection of citizens, but on an issue of governance. In other words, the national courts do not take issue with the way the Court of Justice protects the rights of the individual. What they take issue with is the way it interprets the treaty in such a way as to shift the paradigm of governance in favor of the EU. Your second question, has Article 2 been influential in defining the essence of right? Not really. I don't think it has. Where it has been influential has been essentially in expanding the scope of application of the Charter. So the court, by using Article 2 and using this idea of adequate remedies in Article 19, it essentially has expanded the application of the EU Charter, and it has imposed systemic obligations on the member states, not obligations of government. So judicial independence, the problem with the issues regarding judicial independence have arisen as a result of the rule of law crisis in Poland and Hungary. And essentially what the court is saying is that a member state must ensure that its judiciary is independent, otherwise it wouldn't be possible for the judiciary to apply EU law in a meaningful way. And that, of course, begs the question, what are the systemic guarantees should there be as a matter of EU law? One can think of some. It's not only judicial independence. It would, for example, if, say, Italy from now on required a court fee of $20,000, you couldn't go to court unless you first pay $20,000. That doesn't apply specifically to EU law claims. It applies across the board in my hypothetical, but the Court of Justice would say, well, by having that restriction on due process, you are inevitably making it excessively difficult to assert EU rights, and therefore that would not fulfill the minimum requirements that the member state must guarantee in their administration of justice. But this, as I said earlier, in two very recent cases decided some months ago, appears to be expanding to democratic guarantees, the way political parties should be recognized, the citizen participation in political parties, and so on and so forth. So yes, Article 2 is used, but not in a way one would expect perhaps to be used to interpret other specific rights. It does have an interpretational value, but it is not particularly obvious.
Takis, let me inject myself with another question. Maybe we have time for another one after that. And force you just a little bit into the transatlantic comparison, just a little bit. You speak very often of European integration. And I'll just throw it out there, which is aggressive and uncalled for and might expose me to an ICE intervention when I leave the building. Are we looking at a phase, a beginning, budding phase of American disintegration? Let me be more precise. I was fascinated by your multidimensional balancing. And it reminded me very much of cases like US v. Windsor or Obergefell, where you find exactly the same mix of different themes. You find, of course, the question of judicial review and separation of powers. Should the US Supreme Court be engaging in this question at all? And you have Scalia, who's very forceful and says we shouldn't even be looking at this. Then you have, of course, the substantive question of same-sex marriage, which is a human rights issue. And then you have the federalism question, which side should be actually deciding this? Should this be decided at the federal level? Should we leave it to the courts at state level? And looking at the United States, I fear, just a little bit from a federalism point of view, that we're looking at a system that is slowly devolving things downwards, whereas the Europeans are still integrating things and devolving things upwards, which is what you described very nicely in your lecture. Question, are we in Europe looking at the future when we look at, if my analysis, which is brief and superficial, is right, are we looking at the future of the European Union if we look at the United States currently with a downwards devolution? And Dobbs is a good example of it. Let the states deal with abortion, and suddenly we have a fragmentation of this right, and it depends on which state you're in. Could that be the future of the European Union in light of the rise of far-right parties and more or less centrist policies at the state level, member state level, which would increase the level of tension between the member states and the central level, the European Union?
It's not inconceivable. It is not inconceivable. I think that well, the way one of the judges of the Court of Justice put it to me is, well, you don't go out in the rain without holding an umbrella. And one would need to see.
That sounds like Justice Ruth Bader Ginsburg in a ruling that we had in the United States of America.
One needs to see how things really will evolve. I mean, migration, for example, is an issue where there is very significant political backlash in many countries. I see it less in competence issues. I think it's likely to have more differentiation in the way these fundamental rights are applied, but I don't think it is necessarily going to lead to reducing the competence of the European Union. In other words, looking at the recent cases or what appears to be coming in relation to the Commerce Clause, for example, the Texan case, which appears to suggest that it is perfectly right to do things that one thought they cannot be done in previous case law. I think the EU is not going to, does not appear to go to the same trajectory at the moment. But in relation to the way rights will be applied, I think that's you may well be correct.
Now, not a question, not a follow-up question, but just a remark. Maybe it's the difference between a nation state as a member state, a nation state, and just in inverted commas, a state of one of 50 of a nation state. If you relax your hand too much in Europe, it might disintegrate. It might just, kind of fall apart. Whereas here, that risk is much smaller.
Yes.
No doubt. Yes. Are there further questions? Yes, Mateusz, please.
Yes, thank you. I'm Mateusz Rochowski. I'm an associate professor at Tulane. My question concerns something that was not mentioned by you directly, but I think that was somehow like looming behind many of your theses. So the question of the horizontal effect of fundamental rights, because some of the cases you discussed were like clearly about like the vertical effect, so like the individual state relation, but some of them were about the horizontal. So for example, Google Spain probably would never happen in the US or would not happen in the same fashion as it happened in the EU, because there is no like established doctrine of horizontal effect in the US. And now the question is, to what extent the story you told today would be different if the EU did not recognize the horizontal effect? Because many of the cases you discussed, so for example, and many of the problems you discussed, so for example, problems related to effectiveness, judicial protection, related to, like you didn't mention that, but for example, there is a huge case law related to Article 47 of the Charter, so the right to effective judicial remedy, which originates in like clearly like horizontal settings. So for example, consumer to business contracts. To what extent this architecture of fundamental rights and this European constitutionalism would be different if we didn't have this body of cases which were like animated, fueled by this like German concept of horizontal effects, of the idea that we can enforce fundamental rights in the like individual to individual relations, not only state individual dimension.
Yeah, that's extremely interesting, and you're right. I didn't mention it, although it is a particularly distinct a quality of EU law compared to US law. And I think you're absolutely right that some of the rulings of the Court of Justice horizontality go very far because they touch also on social rights, not in fact. Primarily, I would say they touch on social rights. To what extent would the case law be different? Well, one could separate. I mean, I don't think it is necessary to have a rigorous protection of I don't think that recognizing horizontality is a condition of providing for rigorous protection of fundamental rights. The problem sometimes I have with horizontality is that to the extent that the court reads EU statutes as mere expressions of constitutional rights, and that's necessary because because of the peculiarities of EU law, some EU measures cannot have horizontal effect, like unimplemented directives. The tendency of the court is to say, well, although this right is provided in a measure that cannot bind an individual, in fact, this right doesn't come from the measure, it comes from the treaty itself or from the charter. And therefore, it is horizontal because it emanates not from the legislature, but it emanates from the constitutional bargain, as it were. The difficulty with that is that if it is a constitutional right, it would be much more difficult for the legislature to change it. And there is a risk of oscillation of the law there. It is not, it doesn't necessarily follow because, as I said earlier, there are examples of cases where the court uses legislation, once legislation is adopted, accepts that a constitutional right is less broad as it has been understood by the legislature. So I think there are exit routes. But you are correct. Horizontality is an important aspect, and it is also an important. It is in many cases now provided by different kinds of EU measures. For the Digital Services Act is an important statute in the EU, which really provides for very comprehensive regulation of online platforms in a way that goes much further than other systems. And it's all, it seeks to essentially to rein private power. But yeah, it is a very distinct aspect.
Thank you.
Thank you.
Colleagues, Takis, I'm hungry. Are you hungry?
Yes, come on. Keep running.